converted to a church. Amen. Welcome back to this session, which was adjourned to this afternoon. And for now, until we have given our decision on the matter that was raised in the morning, is the only business upon us until the decision is read out. Therefore, ask my co-chair to read part of the decision, and then he'll go as far as he can or to the end, and then I'll conclude the final part. Co-chair.
Fellow members of the committee, commissioners of the Independent Electoral and Boundaries Commission, ladies and gentlemen, this is the ruling on the preliminary objection raised by the Independent Electoral and Boundaries Commission on the invitation to appear before the Joint Parliamentary Committee on matters relating to Independent Electoral and Boundaries Commission, dated the 29th of July, 2016. And the reads as follows. Number one, the Senate and the National Assembly on the 5th of July 2016 and Wednesday 6th July 2016 respectively approved a motion that established a joint parliamentary select committee on matters relating to Independent Electoral and Boundaries Commission, IEBC. The mandate of the committee is as follows. A, inquire into allegations against the Independent Electoral and Boundaries Commission, IEBC, commissioners and secretariat. B, on the findings of A above, may recommend legal mechanisms for vacation from office of the current commissioners of the Independent Electoral and Boundaries Commission and the Secretariat in accordance with the Constitution. C, recommend legal, policy, and institutional reforms to strengthen the Independent Electoral and Boundaries Commission and improve the electoral system and processes so as to ensure the August 2017 elections are free, fair, and administered in an impartial, efficient, simple, accurate, verifiable, secure, accountable, and transparent manner. And D, on the basis of the findings and recommendations in A, B, and C, prepare a report and a draft bill on draft bills. So that's the mandate of the committee. 2, the committee was further required to receive views from experts, members of the public, business community, civil society, religious groups, political parties, county governments, and any other persons on matters relating to Independent Electoral and Boundaries Commission and the electoral process. 3, pursuant to the motion, by letter dated 19th of July 2016, the committee, through the clerks of both houses of parliament, wrote to a chair of the commission, inviting the commission to make distinct representations on any or all of the thematic areas. Thematic area number 1 was allegations against commissioners and secretariat of the Independent Electoral and Boundaries Commission, specifically on A, credibility, B, impartiality, C, integrity, and D, independence. On thematic area number 2 were to make recommendations on legal mechanisms for the vacation from office of the current commissioners and the Secretariat of the Independent Electoral and Boundaries Commission in accordance with the Constitution. Thematic area number 3, we are to make recommendations on legal, policy, and institutional reforms to strengthen the Independent Electoral and Boundaries Commission so as to ensure that the August 2017 elections are free and fair and are administered in an impartial, efficient, simple, accurate, verifiable, secure, accountable, and transparent manner. The submissions should address the following issues. A, composition of the Independent Electoral and Boundaries Commission and the Secretariat. And B, appointment, term of office, terms of service, and removal from office of the Commissioners and the Secretariat of the Independent Electoral and Boundaries Commission. Thematic area number 4, we are to recommend on legal, policy, and institutional reforms to improve the electoral system and the processes so as to ensure that the August 2017 elections are free and fair and administered in an impartial, efficient, simple, accurate, verifiable, secure, accountable, and transparent manner. The submission should address the following issues. A, voter registration. B, voter education. C, nomination and registration of candidates. D, campaign management. E, publicity and media. F, use of information communication technology in elections. G, voting process. H, transmission and declaration of election results. I, allocation of special seats. J, election observation, monitoring, and evaluation. And K, dispute resolution, including nomination and petitions. 4, the Commission was invited to a meeting with a committee which was initially slated for 27th of July 2016. In subsequent letters dated 22nd July 2016 and 26th July 2016, the date of the meeting was postponed to 1st of August 2016, and it was further clarified that the invitation was extended to the commissioners, the commission secretary or chief executive officer, and all the senior staff of the commission. By a further letter dated 29th July 2016, the committee informed the commission that in the course of its proceedings, the committee had received various allegations against members and the secretariat of the commission. These allegations were set out in the letter, which was copied to all commissioners and the members of the secretariat who were specifically cited. 6. The letter dated 1st of August 2016, the chairperson of the commission wrote to a clerk of parliament raising the following objections in respect to a letter dated 29th July 2016, and we quote: 1. Having reviewed the terms of reference of this committee, the commission would like to raise objections to this committee's terms of reference. Number 1 and 2. It is apparent that one of the outcomes of this process is to come up with reasons for removal of commissioners of IEBC, and further to propose mechanisms for their removal. The terms of reference 1 and 2 are therefore contrary to the express provisions of Article 251 of the Constitution, which sets out the grounds and mechanism of removal of commissioners. 2. Whereas Article 251 of the Constitution enables the National Assembly to receive allegations from public at large, which allegation, if the National Assembly finds merit, may lead to removal of commissioners. The Commission notes that at the beginning of this process, the National Assembly was not in receipt of any allegations. What the National Assembly and the Senate have done is to go out and solicit for allegations against the commissioners in a manner not contemplated under Article 251 of the Constitution. 3. Article 251 of the Constitution vests the National Assembly with important role in the constitutional processes for removing commissioners of IEBC. That role is to hear petitions that have been brought for removal of the commissioners. The Joint Committee of Parliament, which includes members of the National Assembly, has participated in the collection and the coalition of allegations for removal of commissioners of IEBC. If the same assembly were to proceed to hear a petition on the grounds that it has collected for removal of commissioners of IEBC, that will be a violation of the right to fair hearing of commissioners, which right is protected under Article 59 as read with Article 25 of the Constitution. A petition is only a mechanism available to the public for removal of commissioners of IEBC. 7. The Commission invited the Joint Committee to make a determination of the preliminary objections. From the letter and the oral submissions made by the Commission, the following are the issues requiring determination by the co-chairpersons of this committee. 1. Whether the terms of reference cited in thematic area number 1 and 2 are contrary to express provisions of Article 251 of the Constitution, which sets out the grounds and mechanisms of removal of commissioners. 2. Whether the National Assembly and the Senate have, through the processes undertaken by the committee, gone out and solicited for allegations against commissioners in a manner not contemplated under Article 251 of the Constitution. And 3, whether the participation of members of the National Assembly in the committee violates the rights of the commissioners to a fair hearing as contemplated in Article 50 of the Constitution, as read in Article 25 of the Constitution, as a petition is the only mechanism available to the public for removal of commissioners. Before addressing these specific and weight issues raised by the Commission, it is important to recall the events leading to establishment of this committee, which are set out in the motion as adopted by both houses of Parliament. Parliament, in the motion, acknowledged that pursuant to Article 1 of the Constitution, all sovereign power belongs to the people of Kenya and may be exercised directly or indirectly through their democratically elected representatives in accordance with the Constitution. Parliament further recognized that through pronouncements, sections of the Kenyan society and raised issues of credibility, integrity, and independence of the Commission, the electoral processes, and the electoral law. It is on this basis the Houses then resolved in accordance with Articles 1, and 2 of the Constitution and Rule 9 on both Houses of Parliament, which relate to joint sittings, to establish this committee. I now hand over to my co-chair to proceed with the rest of the ruling. The co-chair.
Thank you, co-chair. The first aspect of the preliminary objection of the Commission is whether the terms of reference as cited in thematic areas number 1 and 2 are contrary to the express provisions of Article 25 of the Constitution, which sets out grounds and mechanisms of removal of commissioners from office. It is important to state at the outset that Parliament, in the execution of its representative, legislative, or oversight mandate, and in accordance with Articles 1, 94, 95, and 96 of the Constitution, has the jurisdiction to inquire into any matter. For this purpose, Article 124, Sub-Article 1 of the Constitution empowers each House of Parliament to establish committees. Further, pursuant to Article 124, Sub-Article 2 of the Constitution, Parliament may establish joint committees consisting of members of both Houses of Parliament. The Joint Parliamentary Select Committee is therefore a joint committee established pursuant to Article 125, Sub-Article 2 of the Constitution, and the standing orders of both Houses of Parliament, with the mandate of inquiring into the matters set out in the motion. The joint committee is therefore not established pursuant to Article 251 of the Constitution, and is therefore not the Committee of the National Assembly contemplated under Standing Order 2030, paragraph 3 of the National Assembly Standing Orders. Further, it is instructive to note that the motion as passed by both Houses of Parliament does not speak to the question of removal from office in accordance with Article 251 of the Constitution, but rather mandates the committee, where appropriate, to recommend legal mechanisms for the vacation from office of the current commissioners. The mandate of the committee is not restricted to the matter of vacation from office of the commissioners and the secretariat. A significant portion of the mandate of the committee extends to legal, policy, and institutional reforms to strengthen the commission and to improve the electoral system and processes. The role of the Joint Committee is therefore a role that is much broader than that contemplated of a committee established under Standing Order 2030, paragraph 3 of the National Assembly Standing Orders to consider 230 to consider a petition for the removal of a commissioner pursuant to Article 251 of the Constitution. It is further important to observe that Article 251 of the Constitution provides for removal from office for the grounds enumerated in Article 251, Sub-Article 1, but does not provide for the myriad of other means by which a commissioner may vacate office other than by way of removal. On the question of whether the National Assembly and the Senate have, through the process undertaken by the committee, gone out and solicited for allegations against the commissioners in a manner not contemplated under Article 251 of the Constitution. First, as we have stated above, the proceedings of this committee are not proceedings undertaken in terms of Article 251 of the Constitution, and are not of themselves intended to result in the removal of any or all of the commissioners in accordance with Article 251 of the Constitution. Additionally, in the preamble to the motion, Parliament recognized that there were pronouncements which were in the public domain and through which sections of society had raised issues on the credibility, impartiality, integrity, and independence of the Commission. The motion as passed by Parliament therefore required the committee to inquire into the allegations against the Independent Electoral and Boundaries Commission commissioners and the Secretariat. In this regard, the committee was mandated to receive views from the public generally on any such allegations. In the course of its proceedings, the committee received a number of allegations against the commissioners and the Secretariat of the Commission. In accordance with the rules of natural justice, the committee resolved to forward all such allegations to the Commission so as to give the Commission an opportunity to respond to any of the allegations. These are the allegations set out in the letter dated 29th July 2016. In that letter, as well as in previous letters to the Commission, like all other stakeholders who are invited to appear before the committee, was invited to appear before the committee and to make representation on any or all the thematic areas identified by the committee. The Commission would therefore be within its rights to make representation on all, some, or none of the thematic areas. Indeed, some of the persons and institutions who appeared before the committee restricted themselves to specific thematic areas which they felt competent to address. It is for this reason that the letter to the Commission, just like that of other stakeholders, was an invitation to appear and make representations and not a summons to appear. On the question of whether the participation of members of the National Assembly in the committee violates the rights of the commissioners to a fair hearing, contemplated under Article 50 of the Constitution as read with Article 25 of the Constitution, as a petition is the only mechanism available to the public for the removal of commissioners. We have already established above that the mandate and processes of this committee are independent of and distinct from the processes for removal of a member of the Commission under Article 251 of the Constitution. Consequently, the objection by the Commission that the discharge of the mandate of this committee would affect any processes under Article 251, if any were to be set in motion, is premature and anticipatory. The upshot of this, therefore, is that the Commission, in accordance with the rules of natural justice, has been informed of the allegations received by the committee against the Commission generally, specific commissioners, and specific members of the Secretariat. It is therefore open to the Commission, its commissioners, or its Secretariat to respond to these allegations. It is equally open to the Commission to opt not to respond to these allegations and to instead make representation on any of the other thematic areas. We shall therefore proceed in this manner and shall start by asking the Commission to indicate how it wishes to proceed. This decision is the decision of the committee on this first day of August, the year of our Lord 2016, signed on behalf of the committee by the co-chairs on this day of 1st August 2016. And therefore I yield to the co-chair.
Thank you, co-chair. That's our ruling on your preliminary objection, Commission. I will ask the Secretariat to avail a copy of our ruling to you.